Danger invites rescue, and U.S. Marines are trained to spring into action. One Marine's instinctive response to a sudden restaurant fire gave the court a chance to ponder the rescue doctrine in Clinkscales versus Nelson Securities. James Clinkscales, an active-duty Marine visiting Davenport as a recruiter, went to the gallery lounge on a Friday afternoon. He sat down next to a woman named Dimples and ordered a pitcher of beer. As it did most Fridays in summer, the gallery had its grill going on the patio outside the bar. The grill was large enough to cook 20 burgers at a time. 2 propane tanks under the grill provided power. Cook Joe Moser flipped a particularly greasy batch of burgers, ignoring a sudden fire that flared up under the grill. There was a sudden pop and hiss, and the grill and propane tanks were engulfed in flames. The gallery's owner, Caroline Nelson, told the patrons to leave. Nelson handed a fire extinguisher to a patron who extinguished the flame. Moser could still smell gas. He tried to turn the tanks off, but the handles were too hot. Clinkscales had received extensive training in fire suppression in the military. Realizing that the situation was extremely dangerous, he took off his shirt, wrapped it around his hand, and turned the gas off. The fire flared up again, and Clinkscales was badly burned, though he still aided a woman in escaping the premises. Clinkscales sued the gallery for negligence, arguing that it failed to properly maintain the grill and train its employees. The trial court held that the gallery's negligence wasn't a proximate cause of Clinkscales' injuries, because Clinkscales turning off the gas was a superseding cause. It granted the gallery summary judgment. The Court of Appeals held that the rescue doctrine didn't apply, because no one was in any danger until Clinkscales placed himself in danger and suffered a self-inflicted wound. It affirmed the lower court's decision. Clinkscales appealed to the Iowa Supreme Court.